Yes, Counsel.
Yes.
Good morning.
Good morning, Mr. Chief Justice. Good morning, Your Honors. My name is David Keeley, and I represent the defendant, Alexander Molina. What I'd like to do today, Your Honors, is first start off with, unless the court has other ideas, start off with the invocation of counsel, and then move on to custody, and lastly, address the harmless error standard. So with that, Your Honors, invocation of counsel. Right at the outset of the interrogation, the police read the Miranda rights to Mr. Molina, and immediately says to them, but I just said if I could call my lawyer, and I was told it wasn't necessary.
But we don't have, that we don't have transcribed or anything. That's his rendition of something that had happened before. Is that right?
That's right, Your Honor. But what we do have is a transcript of him saying that, and that transcript is going to come up along with the two videotapes of the interview. And I just would like to point out that here we are at the SJC, and that was said has never been challenged by the Commonwealth, not at the suppression motion, not in the appeals court, and not now.
Was he in custody at the time?
Well, Judge, I say he was, and I'm going to get to that.
You mean the Commonwealth has never challenged
No,
or questioned that before he said that happened? Is that what you're saying?
He said it.
I know he said it, because
Right.
we have that, but has anybody ever questioned whether, in fact, that happened, that he was told that?
No, not that I'm aware of, Your Honor. I'd like to quickly go back to Justice Spina's question. He was not in custody at that point, right, at the first invocation of counsel, or mention of counsel. I misspoke. I apologize, Your Honor.
So what's the consequence of not being in custody?
Well, as far as custodial, it's not a custodial claim at that point, but my argument is that he makes a second one at a point when he is in custody.
But dealing with the first.
Yes.
The Miranda rights didn't attach at that point.
No, they didn't, but they're given, Your Honor. The Miranda rights don't attach, but they're given, and I don't think once given, I think the police can't take steps to thwart them, which is exactly what happened here.
Thwart them the first time or the second time?
Well, the first time. I mean, he's saying, look, he's basically saying, in a pre-waiver context, this court on the clock is not requiring absolute clarity. He's basically saying, look, I want to call my lawyer. I want a lawyer.
But they told him he didn't need one.
That's right, Your Honor, and I think that is something that the police should not have done in this case. He's a suspect. According to Trooper Dumont, he's a suspect. Now, the record doesn't show which of, he was either Trooper Serrano or it was Detective Dumont that said, you don't need one. Now, I mean, if it's Dumont, he's saying to my client, look, you don't need a lawyer. Well, he knows he's a suspect.
Was he re-Mirandized during this time?
No, you get Miranda
Only
once,
time.
right at the outset, and then.
Yeah, it seems to me that one of the consequences of what you're suggesting, or what you're arguing, is that it would discourage police officers from telling defendants who are not in custody that they have a right to a lawyer.
I don't think so, Your Honor. I think.
Why would they say it? Why would they advise him of the Miranda rights if he's not in custody?
Judge, I'd love to make the argument that right at the outset of that interview that he's in custody at that point, but I mean, that's not an argument I can make in good faith, so I'm not going to make it. But he's in custody pretty soon thereafter, according to my argument. But I believe the cases say it's good practice to give Miranda, even if custody is not present, and that's what they did. But I don't think the law should tolerate they're giving a Miranda and then the intentional thwarting of it.
But help me to understand the analysis. Do you agree that until he's in custody, the analysis is a voluntariness analysis and not a Miranda analysis?
Well, I think there are two, and you do have to have a voluntariness aspect to the waiver of the Miranda, and he doesn't voluntarily waive it for the reason that it's thwarted.
Okay,
by the police.
if he's not in custody, you don't need a Miranda waiver, correct? I mean,
That's correct.
So would the analysis not be a pure voluntariness analysis up until the point that he's in custody?
If you're not in custody, yes, then you land on voluntariness, which I think he's really, I say he's ignorant of his right to counsel when he's read those rights. There's a remark either immediately afterward, right contemporaneous, there's a remark, look, I want to call my lawyer. I want to call my lawyer. It's not necessary. The police are usurping his right to his invocation of counsel there. They're wedging themselves right in there, right in the middle of it.
But it sounds as if it's not so much that he didn't understand his right to counsel as much as you're claiming that they diminished the need for him to do so, essentially saying, you don't need, we're just looking to see why your car was there. You don't need to worry about that. I mean, that's different from saying you don't have the right. That's from saying you have the right, but there's no reason for you to be invoking it.
I personally wouldn't make that distinction, and I don't think it makes any sense in these circumstances. The police tell him he's got a right to counsel, and then they thwart it. How can he possibly understand, as a common man, what the right to counsel is when he's told he has the right and then it's taken away from him? So there's a bad resonance to that, Your Honor.
But how many times did he get given Miranda rights?
One time at the outset.
Just once?
Yes, and this was nearly 3 hour, so it was a 3-hour interrogation.
So
And so,
that you could argue, but you don't, that then maybe they should re-Mirandize when they get to the point of custodial interrogation so that it's clear that what we said before as police, that it doesn't matter now. Now it's going to matter.
well, I look at the cases, Your Honor, and the cases say 2.5, 3 hours in, they don't need to re-Mirandize, so I didn't even think to make the argument that they should have given it later on. My argument is that custody occurs much, much sooner than the motion judge found. Motion judge finds it at page 270 or something of that transcript that was made of that bilingual transcript. And I say it came much earlier. I say it came pretty much at the same time that he makes his second attorney reference, which is, I quote, "If I had known this would be like this, I honestly would have brought an attorney. It's like my rights are being violated."
This is when he was asked to name some other person?
Yes, but that's in the first third of the interrogation. And I say, if you consider what he's already said at the outset, the police have interjected their own thoughts. They've sort of, in my humble opinion, they've blocked his right to counsel, or at least said poo-pooed it. I say they snookered him.
They misled him?
They misled him, according to Groom. I mean, it's frowned upon by this court. Police have no business telling him it's not necessary, particularly, as I said earlier, now Trooper Dumont considers him a suspect. So look, they know what they want to do here. The police know exactly what they want to do here. So, and then here comes the second attorney reference, and in the appeals court, I asked the appeals court to consider those two statements together. And if you have that completed, sort of with the second one, if the invocation of counsel is complete at that point, and now you have custody, okay.
Well, I take it at this point, the interview is not accusatory, right?
Oh, it's accusatory by page 97, in my opinion, Your Honor, and that's what our argument is. It becomes accusatory much earlier than what the motion judge found. And I mean, it's clear error analysis, but I say the judge was clearly erroneous in finding that custody occurred much, much, much later in the interview. I'm straying into might be a good time just to segue into custody because, the motion judge himself found it was a small room. Mr. Molina is sitting further away from the door than the two police officers. It's two police officers. It's kind of 2-on-1, if I could use that phrase. Again, Trooper Dumont considers him a suspect right at the outset of the interrogation, and which is the second point of this need analysis.
That's because he said that, or because you infer that?
Oh, he testifies to it at the suppression hearing. Let's be clear on that. Detective Dumont testifies at the suppression hearing that he considered Mr. Molina to be a suspect at that point.
Okay, so your contention is that statement with regard to attorneys was not only improper, but also misleading?
Yes, it was.
At the time it was made, not later?
Right. And also, Judge, it's our argument that he was a suspect was conveyed to him. Not in so many words, but by accusations. By page 97, the interview, they're becoming scornful of him, and they're brushing aside his confusion. I mean, it's all cited in the brief, and it comes right out of the bilingual transcript.
Let me, I'm going back for a second.
Yes, Your Honor.
If I understand from these findings correctly, the troopers have him in the 12 by 8 room, or, and
correct, Your Honor.
the troopers, I think he's a trooper, maybe a police.
They're both
troopers, right?
Well, not at that
Serrano?
time. Dumont was a New Bedford City detective at that point. He is now a state trooper.
But I'm really focusing on Serrano. Okay.
Serrano was a state trooper.
So Serrano says, do you read Spanish? He says yes.
Yep.
He then, Serrano reads, or he reads in Spanish, the Miranda rights,
I believe
correct?
Ms. Molina reads them in Spanish. She has the form in front of him. And the
Okay.
form's in the brief, by the way, Your Honor.
Okay.
I failed to put it.
Including, obviously, the right to counsel, and if you can't afford one. Okay.
Correct.
So then he says, but I was just told, you know, I said I call my lawyer, and they said I wouldn't need one, right?
Right. He hasn't signed yet, by the way, Your Honor.
Okay.
He says. I
And then,
quote-
and then the trooper says, but, ask some question, do you want to talk to me? Do you understand your rights? And he says, which I take it to mean yes.
That's fair to say.
It wasn't, yeah.
That's fair to say.
So you've got a situation where he said, somebody said something misleading to me before, but he's just it's in the context of having it in front of him that he does have a right to an attorney. But you're just saying that the first thing kind of obliterates.
I do, you know, and I think that if I understand the Commonwealth's argument, it is that, well, you know, there was some clarification. Well, we're talking about two different rights here, very similar. In fact, I'm asking the court to follow Clark and in a pre-waiver context of invocation of counsel to do what this court did in Commonwealth versus Clark. But just if there is any clarification, it's about waiving his right to silence, which it's similar. The analysis in the cases, they're very, very close. But we are talking about two different things. And Mr. Molina invoked his right to counsel, which it has to be dealt with separately, Your Honor, I would suggest.
And the consequence of that is you're saying we should suppress only from the point that he was in custody, or we should suppress from the beginning of the interview?
Well, Judge, I would be happy if this court would suppress everything that occurred after page 97.
But I'm sure, but what are you saying, I mean, is it your view that that's what we should do, or simply that you'd be thrilled if we did that?
Well, I'd be even more thrilled if you find a lack of voluntariness, then I think the entire interview goes out.
Okay, but if you lose that, then your next position is that it should be suppressed from the point of custody?
Our custody, yes, yes, page 97. Because the damaging statements come out further along, so that would certainly work for Mr. Molina, I believe.
But you would need us to find that the judge was clearly erroneous to get you back that far.
Right, well, I want to get to page 97 on custody. That's where I believe I need to go. We need to go. So if there aren't any questions on any more on custody or the invocation, I would just briefly make some comments about prejudice. And at the trial, the prosecutor's open statement, I mean, stresses the color of the T-shirt that the shooter wore. That was a yellow T-shirt. And then Trooper Serrano testifies to some of Mr. Molina's statements during the interview. Mr. Molina himself says that he wore a yellow T-shirt that day, and because that corroborates the only Commonwealth witness, Barbara. Barbara was out on a porch with Cindy, and Barbara says that Mr. Molina was the shooter who wore a yellow shirt. That's the only Commonwealth witness that says that. The other two women that are out there are three, Alice, Barbara, and Claire. Alice and Claire say that the shooter wore a yellow shirt. No, I'm sorry. Claire doesn't even go that far. Claire doesn't remember who wore what the shooter wore that day.
If we don't agree with you that the defendant was in custody on as of page 97, and what's your alternative theory, if you have one, for excluding everything from page 97 and to some other point thereafter?
Well, Judge, that's the toughest question I think that the case presents, to be honest with you, Your Honor. And I would say that the entire interview should go out on voluntariness based on the initial invocation of counsel, even though it wasn't made at a time when Mr. Mooney was in custody. And I say that because I don't think this court, or the law of the Commonwealth should allow a situation where the police give Miranda, even when there's no custody, give Miranda and then thwart it. That just doesn't make any sense to me. I couldn't find a case that supports, on point, that supports the argument I'm making right now, but it just doesn't make any sense. The cases say that, well, if there's no custody, you can forget Miranda. I mean, I can't go, I mean, those cases, they say it over and over and over and over again. But for the police to give the Miranda, and the interview's going to begin, one of the two interviewers thinks he's a suspect, and then to block his invocation, it doesn't seem right. At some basic level, it doesn't seem right. So I would ask the
You're
court,
saying it's not fair,
it's not fair.
but we'll have to leave it there.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, David Gold for the Commonwealth. I'll pick up where my brother left off if the Court permits me to. Whether Trooper, at the time, Detective Dumont, testified that he believed, subjectively believed, that the defendant was a suspect, which I don't dispute. He did say that during his testimony at the suppression hearing. What's important for this Court to consider is whether he conveyed that to the defendant during this interview, and that goes into my custody argument. As the Court knows, the Commonwealth's position is that the defendant was not in custody up until the point found by Judge McLaughlin, which was at page 247 of the transcript.
But do you agree that the defendant said, quote, "But I just said if I could call my attorney and I was told that it wasn't necessary," end of quote?
I agree that I don't think it's disputed that the transcript shows that he said that. I will point out, though, that there was some discussion of this at the suppression hearing. At the suppression hearing, counsel started out by saying he thought that Officer Brown, who testified, it was one of the responding officers, he thought that he was the one that actually said that statement to the defendant.
Do you agree that he had been given the Miranda warnings at some point prior to having said what I just quoted?
He read, yes, Your Honor, he read the Miranda warning. In fact, the defendant was reading them out loud. Trooper Serrano had the defendant read them out loud in Spanish, and at that point the defendant essentially interrupted himself and said, "But I just said," and perhaps I'm not quoting it directly, but I just said, "if I could call a lawyer," and I was told that one wasn't needed. But I think it's important to point out that the fact that it was said doesn't necessarily mean that it was actually done. Again, at the suppression hearing, the defendant, at the outset of the hearing, said he thought that Officer Brown was the one that told him that.
Sorry, finish your
Oh,
thought.
I'm sorry. Officer Brown testified that he never told him that. Trooper Dumont also testified, Detective Dumont also testified that he didn't do it and he didn't hear anyone tell him that. So all we have is the defendant's statement that I was told. We don't know who the defendant is saying told him that. That fact is just not developed right now.
Okay.
But he said it.
If he had been told that it wasn't necessary, do you agree that that would be a problem?
No, again, I would need more context as to when the remark was said. I don't know if he was told by a police officer that it was not necessary for him to call a lawyer. I'm not sure what the defendant's question was to the officer. But again, at this point, I think we all agree, including counsel for the defendant, that the defendant wasn't in custody, so he didn't have any constitutional right at that point to have an attorney with him. Again, I think it's important that assuming what the defendant said at the outset of the interview is correct, that somebody did tell him that was technically correct. Your Fifth Amendment right to an attorney doesn't attach unless there's a custodial interrogation.
But if the police officers had said to him, "Look, why don't you sit down and talk with us, and anything you say to us, we will never use it against you," could they be held to that?
Can they be held to that? I think in that circumstance, again, it's going to be determined that he wasn't in your fact pattern. I'm not sure if he's in custody or not in custody.
Not in custody.
If he's not in custody, then there's no actual right to an attorney. So I'm not sure I understand what the court's question is.
No, if they say to him, sit down and talk to us about what happened. Anything you say to us will never be used against you. Can they be bound to that?
I'm not sure.
We actually had a case like that, but I don't remember what we said.
It was Tremblay, but it was off the record.
Off the record.
Oh, I see.
Let me ask you this. So this whole Miranda thing is meaningless because it was not given while the defendant was in custody? What are we doing here? Is this meaningless, this Miranda stuff, because he was not in custody, therefore, ha, ha, ha?
They can
you
just
have a right-
misrepresent what it says. I'm not saying that's what happened, but could they, theoretically?
I'm not misrepresent what,
What Miranda warnings are?
well, the Miranda warnings, again, attach only, and they're designed to protect a very specific instance, and they're for custodial interrogation. Two things need to be shown: that first, the defendant was in custody, and second, that the questions were interrogation, constituted interrogation.
But at what point, and you're leaving it to a defendant or a suspect or someone who's brought in for questioning, you give it a prophylactic Miranda way at the beginning, everything's friendly, then things heat up, and he said, don't worry about it, you don't need a lawyer. Is that person supposed to say to him, oh, what they said before, I guess that applies now. Now I'm in custody, so by the way, how about now? Is that what you're asking?
I think that's what the Miranda warnings are designed to, and that's why the
Well, they're
Commonwealth has to
designed
prove beyond.
for not to be given prophylactically. They're designed to be telling a suspect, you're a suspect, and anything you may say may be used against you, and you're entitled to a lawyer, et cetera. But if you give it prophylactically and then take away the impact and don't say them again at the point when they do count, what's a suspect to do?
Sure, I think that early on, when in the hypothetical situation where they actually are required, where the Commonwealth actually has to prove beyond a reasonable doubt that the defendant actually waived those rights, I think in those circumstances, the defendant has understood his rights. The Commonwealth has shown beyond a reasonable doubt that he waived those rights.
Either you're missing the point or I'm missing the point. This case,
Yes.
let's assume the defendant said, after being advised of his Miranda rights, yeah, I would like to have my lawyer here. And the officer said, no, you don't need a lawyer here. And then proceeded. Eventually, the interrogation became custodial. What's the outcome?
I think in that case, when the interrogation became custodial, I think that would be a better case for the,
What happens when the thing becomes his custodial? Now, his assertion of 2 hours ago applies? Did the police have to stop and say, 2 hours ago you someone had a lawyer, now it's custodial, now actually, yeah, you can have a lawyer. Is that what's supposed to happen?
Sure, I think that in some cases, depending on how long the interrogation goes, and I think my brother referenced those cases, if it's 2.5 hours, 3 hours, and at some point it does in fact become custodial, the better practice for the police department is actually to then re-Mirandize.
But if they
I think
don't?
If they don't, in those circumstances, again, that would be a different case than this one. In those cases, then I think that there might be an issue.
Why is it different
Why is
here?
it different?
Well, it's different because here at the outset of the interview, if I could back up just for a moment. Again, the judge found at page 247 that it did indeed become custodial.
Okay,
Right.
but the only Miranda rights that were given when we
One.
would say it was not custodial, correct?
That's correct.
And so if to take Justice Cordy's, which is a variation on what we have, but if right at that time, the defendant said, oh, I want to call my lawyer, and the police officer said, yeah, you don't need to do that. We're not doing anything really here, and then said nothing more, you would say that would be a problem, right?
I would say so. If that point it became custodial, then that would be essentially an argument that he had invoked his right to counsel at that point. Yeah, sure. I understand that. If I understand the court's question, yes, I think that'd
So
be a
why
problem.
should he be re-Mirandized at that point when it becomes custodial?
Well, again, it would be in the circumstance where if it depends on the timing. Okay, if we're talking an extended period of time, if extended, I think the court has gone up to 3.5 hours. At that point, it might be the better practice to actually re-Mirandize the defendant.
But what about here, where if it were true that one of the officers told him that it wasn't necessary to call his lawyer, and he's under the mistaken belief that it's not necessary to call my lawyer, and we're well into a custodial interrogation, the police weren't required to re-Mirandize him, given at least the statement that was made?
I think that issue may go more towards whether the defendant actually understood what his rights were. I'm not,
Isn't that what we have?
I don't believe so, no. I think that what we have
Why
here is,
not?
well, because the defendant said, but I would just said if I could call my lawyer, and I was told I didn't need one, or whatever his exact words were.
And so that's sort of floating in the atmosphere.
That's right,
And it's never really clarified.
It certainly was, I think, when the officers, after he said that, again, this is assuming that it was, that he was entitled to Miranda rights. I just want to be clear that
No, not assuming.
Assuming they were given.
Assuming they were given.
I think it was if he was entitled to them. If he was entitled to them,
But he didn't get them later, so you got to rely on those as being the Miranda rights that he got, don't you?
he didn't get them later, but the statements were ultimately suppressed. So I guess that's why my argument isn't that if I was certainly at the point that Judge McLaughlin found that it became custodial, that would be a different circumstance. But those statements were suppressed. The Commonwealth didn't challenge them, and the Commonwealth's not challenging that right now.
What was suppressed? I'm sorry, I missed that. What was suppressed?
From page 247 in the transcript onwards, when Judge McLaughlin found that it did in fact turn custodial, that those were actually suppressed. So I'm talking about everything that happened.
The judge's order is the motion to suppress is denied.
I'm sorry, in his is that his order? I mean, in his decision itself, it becomes pretty clear that at 247, page 2, he found it at 247.
I don't see any, I mean, I read it, but I don't recall anywhere where he said, I'm going to suppress the statements made after page 247.
I'm sorry, at 247, he found that it became custodial.
Right.
I apologize.
But he didn't suppress those statements.
He didn't suppress those statements. What he found was that they became custodial. Those statements
Yes, but
ultimately
there
went-
was no, so, but what I'm saying is it became custodial at some point. From my purpose, it doesn't even matter. At some point, but the only Miranda rights that were ever given were back at the beginning, right? So if you have a misunderstanding about what the, whether he, you know, there's been some arguably misinformation about you really don't need a lawyer.
Sure.
Doesn't that go forward to when it does become
and
custodial?
again, I think, I'm sorry if I misunderstood your question earlier. Now I fully see what your question is. At that point, in a certain case, not this case, and I'll tell you why in a moment, that very well may be the case, and I believe those cases discussing the 2.5 or 3 hour cases may say that, do say that, excuse me. But my point is that none of those statements that were made after 247 were actually admitted at trial. They weren't, the defendant's statements that he made afterwards, after 247, after the point where the defendant was found to be in custody. And that perhaps is why my brother didn't raise this argument on appeal. Again, this particular, to give the Miranda warnings again, was never raised in the appeals court. It was never raised here. And I believe the reason why, and I certainly don't want to speak for my brother here, is because those statements ultimately weren't used by the Commonwealth, in fact.
I understood that he would agree that is it necessary as long as you move the custodial needle to a different point and you can to page 97. If you agree with the principle, okay, you don't give Miranda again, but you count invocation no matter when, right? So for him, the argument is, so you count it at page 97 and onward.
As my brother argues that at that point it was, I do understand that to be his argument, that at 97, but backing up, this statement was made, I think on page 6 or 7 of the transcript. I also would note that I do dispute the argument that at page 96 or 97, I'm not sure which one in particular, it became custodial when the defendant made his second mention of an attorney. This court has found, again, putting aside for a moment my custody argument, this court has found that the statement that the defendant made was essentially mulling the possibility of an attorney, and as the appeals court found, the defendant was really stalling here. The question was asked of who gave him the yellow shirt that he claimed to have worn, and at that point he said, I really don't want to answer. If I would have known it was going to be like this, I would have brought a lawyer. That's not an invocation of the right to counsel. But I think we need to look at, if I could just draw the court's brief attention to the groom factors here. We have an interview with the defendant where he was at the police station voluntarily. He was never handcuffed. It was a friendly interview. There was a lot of, characterized as joking around or laughing on the defendant's part. At one point, Judge McLaughlin found that Trooper Serrano was leaning back in his chair, indicating sort of relaxed atmosphere. The defendant ultimately did leave. He was not arrested that night. I also note that on page 207, well past where my brother argues it became custodial, the defendant said, he says, you know what, if you want to arrest me, go ahead and arrest me. That type of statement shows that the defendant didn't think at that point that he was under arrest. He just told the officers that if they wanted to arrest him, to go ahead and do so. There's simply nothing here up before page 247 to show that the defendant was in custody. And again, if I could point to, I know none of the groom factors carried the day. I would definitely point to the nature of the interrogation and the fact that the defendant left after the interrogation as being important. I see that my time is almost up.
I've got one question for you. Is the key here the yellow shirt? I mean, do you agree that if we were to suppress some reference to the yellow shirt, that they would not be harmless error?
Well, again, I understood my brother's argument today to be that he's arguing custodial interrogation at the point right when the defendant made his second reference to an attorney, and the problem for that argument is that was in reference to the fact that the defendant just said he was wearing a yellow shirt. So I'm not sure how, even if this court adopted my brother's argument as to where custody began, how the yellow shirt would not have come in. But yes, I would agree, though, that the yellow shirt was important. I would also point out that there were 2 eyewitnesses that identified the defendant as the shooter. Granted, only one apparently said that he was wearing a yellow shirt. The other one said it was the defendant. So I certainly think that there was strong evidence that the Commonwealth had of his guilt.
All right, counsel, your time is up. Thank you very much.